Yes, Mr. Mallon. Thank you, Manuel. I'm grateful for my learned junior who's reminded me that sections of our skeleton argument do answer some of the questions that you were posed this morning. I've been concentrating on what I might call rather high-level points, but there are some of your questions raised more precise and more technical issues, and can I just draw your attention to where those are addressed in the skeleton? I think if I could ask you to turn to page 10, paragraph 22. The previous paragraph makes the point about the mandatory law and so on, which I've made up, I think. Then coming to 22, we say this: by amending the CJJA to introduce sections 15A to E, the legislator replicated in English law post-Brexit the statutory right enjoyed by consumers and employees under the regulation to sue and be sued in their home jurisdiction, where the subject matter of the proceedings, in the consumer's case, is a matter relating to a consumer contract. That's Articles 17 to 19 of the regulation. We say that's a mandatory rule and secures the objective of protecting consumers as the weaker party to a consumer contract. However, and this is perhaps of some relevance, but it's quite technical, in doing so, it did not adopt the EU regime without adjustment. The regulation itself has been revoked and is not part of retained EU law. The only part of it replicated in English law, pursuant to sections 15A to E, is the jurisdictional protection for consumers and employees, which was formerly found in the regulation. Section 15E2, which we haven't looked at yet, provides that in determining any question as to the meaning or effect of the provisions contained in sections 15A to D, regard is to be had to any relevant principles laid down by the CJU before IP completion day, 31st of December 2020, in relation to Chapter 22 of the regulation. This, for present purposes, this means the court is required to have regard to Article 17 of the regulation in Chapter 2, Section 4, which makes provision for jurisdiction over consumer contracts. On the other hand, the court is not mandated to have regard to Chapter 1, which includes Article 1 of the regulation, which sets the scope of the regulation and includes the arbitration exception under Article 1(2)d. Follows that the hierarchy of the regulation has not been imported to English legislation and so is not relevant. And this is then when we come to the question, I think, that I was being asked just before the short adjournment, when we say, in addition to the subject matter language, which is commonly found in the CJEU judgments considering the scope of the regulation, the English legislature also added, and the nature of the proceedings, and this is the question you asked. And we quote 15A2, and we say in subparagraph 4, by requiring that both the subject matter and the nature of the proceedings are within the scope of the regulation, or do not fall within the exemptions identified in Article 1(2), the UK legislator signalled that the English court is not only concerned with the subject matter, but also the nature of the proceedings. The purpose of this additional language cannot be to narrow the scope of consumer and employee claims, but to signal that in characterising the claim, the court must take a substantive approach. The end result is that as far as 15A2 is concerned, the English court is to have regard to English law when characterising whether a claim is within the scope of the regulation as determined by Article 1. However, the nature of the substantive rights under sections 15B to D are to be interpreted by principles laid down by the CJEU prior to the 31st of December 2020. It follows that English private international law applies to the characterisation of a claim, i.e.
Well, I don't know whether you need to read all this out.
No.
I had this very much, I have this very much in mind. Yes. Your submissions this morning were focused essentially, as I understood it, on what you say the position was under the regulation, without it being necessary for you to argue that there's been any enlargement as a result of Brexit.
Yes.
You've got these additional points, which
exactly.
I might characterise as take-back control points, in which you say that the consumer rights have been enlarged as a result of Brexit. I have those in mind.
They haven't been diminished, and so I didn't want. By not having referred to the detail of some of these arguments, which are best read on paper than they are spoken, because they're quite intricate.
Take them as read. Then.
Exactly.
But why do you say if the legislature has added what appears on its literal face to be an additional requirement for the application of sections 15B and C, why do you say that having to satisfy two requirements gives you broader access or broader application of 15B and C?
Because we're dealing with an exception, so that the same applies to the exception. So you have to satisfy both requirements to come within the exception. So, and obviously, other cases wouldn't be concerned with an exception. They might be concerned with whether you're within one of the other articles, then
sorry, just to 15A2. So sections 15B and 15C apply only if, and then there are the two.
are within the scope of
So-
the regulation as determined by Article 1. That includes the exception. And 15B is consumer, 15C is employee.
But in which case, but are they? I mean, are they two different things, or are they, as was suggested before lunch, perhaps different, but only because of the different nature of the exceptions?
Well, that is one view. There's no answer. I don't know of any case that's considered this.
And I dare say it's a fanciful hope that there's any travo or any guidance from any publication by anybody who actually was responsible for the drafting of these words. Nobody's found anything, presumably.
We can have a look. I'm not aware that. And then the other question that you asked, I think we addressed in another paragraph. I'm just going to draw attention to that.
I don't know whether any of the regulatory authorities, such as the CMA, might have had an input into the drafting of any of this.
I don't know either, but my impression is that they are more focused on the CRA than they are on the CJJA.
But this is a
That's
consumer.
a
This is it's a consumer bit.
Yeah, no, I agree.
I thought that's what they were there for.
I agree it is, but you'll have seen that my learned friend's submissions they only address the CRA and not the CJJA. So that's for him, and he can take instructions on that. But the other question that you asked was about this question about whether my client should have submitted the substantive dispute to the English proceedings, and we also did touch on that in paragraph 32. I'm just going to draw your attention to that, and those are some. I gave some answers on that, but there are some more answers, or you may think it's just another way of saying the same thing as what I already said this morning. But on page 15. We address the argument that you have to bring a substantive claim and then face a Section 9 application in order to get a determination that the arbitration agreement is invalid. And we said that would curtail consumer jurisdictional protection in 3 ways, and we've set them out there. So I just wanted to draw your attention to that, my lord, as well. But that's all I wish to say for the moment on the arbitration exception. But the next point that I indicated I was coming on to before the short adjournment is that we say that in a consumer case such as this, the court can and should take the view that the arbitration exception does not apply because the court itself summarily determines that the arbitration agreement is not binding either under the CJJA or under the CRA. In other words, it can do, in effect, what the German court did in Zellner. And we say, well, we've got a jurisdictional issue before us. We're going to decide that the arbitration agreement is not binding. And because it's not binding, this case doesn't fall within the arbitration exception. So this is my alternative submission. That the court can decide this issue, just as the court did in Zellner. And then the arbitration exception doesn't apply. And the reason it can decide this issue...
That doesn't apply to what? To the issue that you're asking us to decide?
Well, it doesn't apply to deprive the court of jurisdiction. Yes, effectively, yes.
And it's a summary judgment application on your claim.
Well, it's
In all but
determining
name.
determining
You say our claim is bound to succeed, and therefore the court must have jurisdiction.
Yes, that's effectively the point. And the other point, the submissions I'm about to make are relevant in any event to Section 9.4.
That I understand.
So
That I understand.
They're relevant for two reasons. But we do say that this court, there's nothing to stop this court doing what the German court did in Zellner and deciding for itself in a consumer protection case. I'm not saying it could do it in necessarily other cases, but in a consumer protection case, where when the matter comes before it, the court is required to decide on fairness under Section 71(2). It can decide that issue and then, as a result of deciding that, hold that the arbitration exception doesn't apply. It's a very short point. I may be wrong, but that's the point. But in any event, the arguments I'm about to make are all relevant to Section 9.4 in any event. So our submission is that the arbitration agreement is not binding or not valid. Different words are used in different pieces of legislation, either under the Civil Jurisdiction Judgments Act or under the Consumer Rights Act. And we have sought in our appellant's notice a declaration from this court that Clause 17 is unfair and not binding on the claimant. That's core tab 1 at page 7. And I'm going to take this aspect fairly briefly because, in opening anyway, because our arguments are set out quite fully in the skeleton argument at paragraph 33 and onwards. And I'd like to address, first of all, the CJJA and section 15B6 and 15D1, which is in the joint core bundle at tab 1C at page 38. Now, in applying the CJJA, can I just get two initial points out of the way? First of all, there was the concession that my client was a consumer for the purposes of the application and for the purposes of the CJJA. And we saw that this morning. Secondly, the judge held that my client had the better of the argument as to whether the defendants were directing commercial activities in England. And that was paragraph 79 of the judgment. And that is the correct test to apply to a disputed factual issue. And there's been no respondent's notice on that point. So the only reason...
It's the correct test if it's a jurisdictional question. It's not the correct test if it's a Section 9 question.
Correct. The only reason that the judge held for not applying Section 15B6 and 15D1 was that she held that these provisions do not apply to arbitration agreements. And that was in her judgment of paragraph 60. Now, it's a short point, and we submit that she's wrong on that issue, and that an arbitration agreement, such as that in clause 17 here, is an agreement conferring jurisdiction within 15D1, and it does fall within the scope of 15B6, because it takes away the rights in 15B2 and 3 to sue and be sued where the consumer is domiciled. And in fact, and I think there's common ground between myself and my learned friend on this, if it's valid, the New York Arbitration Clause does two things. It confers jurisdiction on the arbitrator to decide the dispute, but it also confers jurisdiction on the US federal courts, New York, I think is the Second Circuit, as the courts with supervisory jurisdiction over the arbitration. Now, we respectfully submit that the starting point for this is on page 37 in the core bundle of authorities, paragraph 15B6. And Sorry, 15B6 should be on page 37. My number. Oh no, I've got the numbering slightly wrong. It's 36, thank you. Subsections 2 and 3, which is the right to sue or to be sued in the place of domicile, may be departed from only by an agreement, A, which is entered into after the dispute has arisen, and then two other provisions that don't apply here. And so we respectfully submit that the arbitration agreement is an agreement which departs from sections 2 and 3, and as it was not entered into after the dispute has arisen, it's contrary to 15B6. And then 15D1...
It's my fault, but you have to start with 15A2, don't you, and decide what section 15B applies to.
Oh,
if you get over that hurdle, then you're home on jurisdiction. And if you don't get over that hurdle, I'm not quite sure how you can say that relying on section 15B gives you the right to have a summary determination of it.
Yes, but I think it's common ground that two of the heads of my client's claims do not fall foul of the arbitration exception.
Well, I understand that, and I entirely understand why you would be dealing with this under section 9.4.
Well, I'm dealing with it in a sort of omnibus way, trying to do it in one place rather than two different...
I know, forgive me, but you are asking us not only to treat it as a section 9.4 point, but to treat it as a point which establishes jurisdiction for what I've called your arbitration claim. And I speak for myself, I'm just having a bit of difficulty in seeing why it isn't circular for that, because if 15A2 means that section 15B applies, you're home anyway, and if it doesn't mean that section 15B applies, I don't see how you can say that it because it deprives you of section 15B rights, you're entitled to jurisdiction.
I don't think we're a variance here. I accept that so far as the arbitration declaration claim is concerned, we've got to have won on the arbitration exception issue for the purpose of this argument.
Right.
So far as the other two claims are concerned, the conflict of laws claim and the Gambling Act claim, there is no arbitration exception issue.
No, you're straight into section 9.
And, yeah. So I accept those are the premises on which I'm making these submissions. But for present purposes, I'm assuming that I'm right in relation to the Arbitration Act claim, that it falls outside the exception. In other words, it's governed by the regulation. Obviously, if I'm wrong about that, these submissions only apply to the other two claims. And under 9.4.
So we're on ground 3, aren't we? I mean, forgive me, I'm just trying to get the structure clear in my mind. I just don't understand how these are really ground 1 or ground 2 points. Perhaps the 15D1 is an ancillary ground 1 point, but
no, 15D. I accept that the point you put to me, which is you don't get to 15B if you haven't succeeded on 15A2. But two of the claims do, and I'm assuming that I have succeeded. So far as the arbitration claim is concerned, I'm assuming I've succeeded on that under the arbitration exception. But I may or may not, obviously. But the arguments are still relevant for the other two claims. Same arguments. So,
Mr. Can I just make sure I'm following this? You mentioned 15D1.
Yes.
If I recall 15A2 correctly, it doesn't refer to 15D, it only refers to 15B and C.
Yes, that's correct.
Does that mean that the exclusion in 15A2 doesn't apply to 15D1?
It could mean that, but the problem is that 15D1 only refers back to 15B and C6 in each case. And it seems to just spell out the consequences of an agreement that doesn't meet the requirements of 15B6 and 15C6.
Yeah. Okay.
So it's a very narrow point I'm making here. I entirely accept that. But there is no case deciding that 15B6 and 15D1 do not apply to arbitration agreements. I entirely accept that one has to come within the, one has to satisfy the requirement of 15A2 to get to this point. But if I'm right on my earlier arguments, we are there. And in any event, there are the other two claims. Now, this is just a short point of construction of the statute. Are these agreements for arbitration on the hypothesis, the different hypotheses, different claims, agreements that fall within the scope of 15B6 and thereby 15D1? Now, it is said by the respondent that this was decided against the appellant by the prestige numbers 3 and 4, a different part than the part we looked at earlier. And in my respectful submission, that is not the ratio, at least, of that part of the judgment that they refer to. And we could go back to that. It's Core Authorities, tab 14. And this is the part of the judgment at page 380, which starts just after the passage we were looking at, which is headed the Section 18 application. So this is the award claims rather than the judgment claims, which was being looked at earlier.
I'm so sorry, I was just making a note. Which paragraph?
Page 380, it starts at paragraph 75.
Thank you.
Right at the bottom of the page, the award claims. There's no text under it, but there's a heading right at the bottom of the page, the award claims. And at 76 it says, for the judge it was common ground that the award claims fell within the arbitration exception, so that the domestic rules for service apply. On appeal, however, the states have withdrawn that concession, contending that the exception does not apply. And this was the argument of Mr. Dilnot, on what's said to be a very narrow basis based on the CJEU decision in Assenshafen. And the relevant paragraphs are at the bottom of the page, 381, paragraph 79. It says, for this purpose, we are prepared to assume that if the regulation applies to the award claims, they would constitute a matter relating to insurance, so as to fall within Section 3. We would accept that where the recast regulation applies, Article 15 sets out the only circumstances in which the parties may contract out of Section 3. That is clear from the article's opening words. But then it is said in paragraph 80, however, before any question as to the effect of Section 3 can arise, a necessary prior question is whether the regulation applies at all. as arbitration in its entirety is excluded from the regulation, there can be no question of Section 3 having any effect in a case in which the arbitration exception in Article 1(2)(d) applies. I agree with that. Section 3 can only apply to matters within the scope of the regulation, does not apply to arbitration, which is excluded from the regulation by exception. And I can agree with that. The next sentence, however, is too broad because it says, whereas exclusive jurisdiction clauses are within the scope of the regulation, arbitration clauses are not. The reason I don't accept that is that it's too broad and too general. It may well be true in 90% of the cases, but it wouldn't be true in our case, for example, where the subject matter of the claims is the consumer protection rights. And then they go on and examine Recital 12, which we've already looked at, the New York Convention, and it concludes, for these reasons, we hold that the reasoning in the Assasshaven cannot apply to an arbitration clause. You know, this is also the view of Professor Briggs. Accordingly, the arbitration exception applies to the award claims, and jurisdiction must be determined in accordance with the domestic law principles. And I would say that that the ratio is simply that the arbitration exception applies to the award claims. The reasoning is a little bit overly broad if it says, as it does in the last paragraph of paragraph 80, arbitration clauses are not within the scope of the regulation. They may be within the scope of the regulation if the rights that are being asserted are themselves rights that are not within the scope of the arbitration exception. But many, many cases, what's stated in paragraph 80 will be true, but it won't be true in every case. So in my respectful submission, that case doesn't determine the point against me for those reasons. Now, that's all I wanted to say, apart from what's in the skeleton, on the CJJA. Turning to the alternative way in which the case is put on the arbitration agreement, this is based on sections 89 to 91 of the Arbitration Act, which expressly provides that the relevant provisions of the Consumer Rights Act apply to arbitration agreements. Taking the first steps, but we start that the appellant is a consumer within the CRA. That was accepted for the purpose of the application. Secondly, the second requirement is that the respondent has to be a trader. The respondent didn't argue that it wasn't a trader at the hearing below. And I don't think it's argued that now. The argument that the respondent did run at the hearing below is that the CRA didn't apply because the matter was governed by New York law and because Section 89 of the Arbitration Act 1996 was restricted to domestic arbitration. And that was covered in the judgment at paragraphs 96 to 98. But the learned judge rejected those arguments, and she held that the Consumer Rights Act did apply, notwithstanding the purported choice of New York law, and that, as I understand, there's no respondent's notice on that. So the starting point for those reasons is that the Consumer Rights Act applies to the arbitration agreement here, and the Section 61 test of unfairness is to be applied, and we submit that it is not binding on the claimant as it was unfair within the meaning of Section 62, subsection 4 and 5. And we submit it's clearly contrary to the fairness test in the Consumer Rights Act, and the court should so hold summarily. And we say that this is obviously a decision that should be made by this court and not delegated to the arbitral tribunal in light of Section 71 of the Consumer Rights Act, to which I will return. But the argument is not a complex argument. The argument is set out in our skeleton at paragraphs 35 to 42. As I will refer you to in due course, there's 4 or 5 cases where the courts have applied these provisions to arbitration agreements, and they've normally decided the point in about 3 or 4 paragraphs. It's not a huge inquiry, and it has to be assessed objectively. And we gratefully adopt the arguments in the skeleton argument of the CMA.
Can I just understand what you mean by assessed objectively? Do you mean that any consumer is entitled to have the fairness question judged by reference to some notional consumer? Or do you accept that in looking at fairness, you have to look at the particular circumstances of the contract in question and the consumer in question?
I think the answer is that it means what the Supreme Court said it meant in Cavendish. I'll show you where that's referred to in a moment. What I was just about to say is we adopt my learned friend Mr. Riley Smith's submissions in paragraphs 9 to 32 of his skeleton argument as well. But we particularly adopt, on this point you've just asked me about, his submission in paragraph 19 of his skeleton argument. Where he says, in the view of the majority of the Supreme Court justices, the test in Aziz was objective. In that case, which was the case about parking charges, Lords Neuberger and Sumption observed, the question is not whether the defendant consumer himself would in fact have agreed to the term imposing the £85 charge in negotiation, but whether a reasonable motorist in his position would have done so. So it's that aspect that's to be assessed objectively. Would a reason, and here transposing that, would a reasonable buyer of NFTs in an auction as a consumer, would he have agreed to arbitration in New York, subject exclusively to New York law in these circumstances?
But in his position. So what? Reasonable motorist in his position?
Yes, in his position.
Reasonable consumer in Mr. Soleymani's position?
Yes.
And does that mean one does take account of factors such as how wealthy he is? In some cases, for a consumer, it's obvious that a lack of access to legal aid, for example, would be a severe disadvantage.
No, I don't. I submit that it doesn't include that. And just as it wouldn't include that in terms of parking charges. It wouldn't go around assessing in every individual case whether the person was wealthy enough for £85 to be something they would agree to or not agree to.
Well, I don't regard that as self-evident.
Okay.
But there may be many people who park and say, I don't mind how much I have to pay by way of a charge. I've got so much money, it doesn't really matter to me. It would be surprising if that weren't a relevant consideration in deciding whether or not it was unfair to enforce against that person. I mean, you may be right about that, but I just want to understand how far you go. So you are essentially saying that Mr. Soleymani falls to be, the fairness of this arbitration agreement for Mr. Soleymani falls to be judged essentially by reference to some notional consumer without any of his attributes, whatever they may be, let us say wealth, access to legal advice, whether he'd read it, whether he'd seen that it applied to arbitration and thought that's fine. All of those are entirely irrelevant.
Well, that's my primary submission. And when I looked at the European decisions, they are very, very brief on this. And this is why we say, it's one of the reasons we say it's a simple, straightforward point. And I'm going to show you one of the earlier decisions. So they decided that the thing was unfair in a few sentences. And they're just looking at the very basic facts of the situation. And not looking at any subjective elements related to the individual concerned. Although, as I said at the very beginning, if one does have to look at...
When you use objective and subjective in distinction from one another, you're often just eliminating an individual's state of mind, his sense of whether it was unfair or
that's
not.
true, yeah.
But you're not necessarily eliminating the characteristics of the person. Because do we assume that the reasonable consumer, or whatever the expression is somebody who has money to spend on buying NFTs from online?
Yeah.
How much money to spend? Is that relevant? Is it the reasonable man you'd find sort of standing outside the Royal Courts, or is it somebody who moves in art circles, or just what is it? I mean, the trouble is it really something that is completely divorced from any of the background context in which this very unusual type of transaction takes place?
Yeah. Well, can I mull that over and not try and answer it on my feet now? Yeah. I'll try and drill down a bit more into that, because in this particular case, as I mentioned right at the outset, we have the evidence of Mr. Soleymani that he didn't see this clause, didn't know what it meant anyway, so it may not make any difference.
Well, that may be subjective evidence.
Yeah, it is subjective.
He didn't read it.
Exactly.
I mean, but if you had to decide whether the reasonable person in his position would have read it, you've probably got to then start digging down into the sort of persons who get involved in this sort of transaction, which is not, it's not every day, walking into Boots the chemist and, buying whatever you're buying Boots, some shampoo or something. I don't know.
There's a number of questions. I accept there's a number of questions. Would they have noticed it? Would they have read it? If they had read it, would they know what it meant? Would they understood the implications? All of those questions arise. But my primary submission, at least, is that the level of sophistication of the consumer, or otherwise, is irrelevant to the analysis. And as a result, also, of the test being an objective one, it doesn't matter what Mr. Soleymani himself did or thought. But there is some evidence on that, if the court thinks it is relevant. His evidence was that he...
Well, as I said, those two things are not the same. What he may have thought or did may not be relevant if it's an objective test, but the characteristics of the person who engages in buying NFTs online, of which he is one, may be relevant to the court's inquiry.
Yeah. Well, the most important factors, as we'll see when we get to the cases, are whether there was drawing attention to this matter, an explanation as to what it meant, and any opportunity or advice to take legal advice, because the law generally in this area really frowns on pre-dispute arbitration agreements. The fact that they're on the grey list is said in some quarters to mean that presumptively they're unfair. Strictly speaking, the grey list says may be considered unfair, but the indication that they're on there, and they're taking away your right to sue and be sued in your place of domicile, is enough to get you quite a long way down the road of being unfair within the terms of the legislation. And these are not detailed inquiries that are conducted, but I will think more, if I may, on the specific question of what it means in this context to say it's objective. But his evidence is, anyway, that he doesn't recall seeing clauses. He had no prior experience of arbitration, didn't know what they meant or what it entailed. Soleymani 1, paragraph 27. And there was, this is the point, that there was no requirement that you read the terms, and including reading the arbitration provision, and there was no requirement that legal advice should be taken by the person using the platform, and it was not suggested anywhere that advice should be taken before agreeing to the terms. So if I can take up our skeleton argument and try to deal with this relatively speedily, but come back to this question of the nature of the test. Paragraph 38, we've set out the basic matters which are to be considered under section 62(4) and 5. Paragraph 39, we've set out the relevant part of the white list, the grey list, that a term which has the object or effect of excluding or hindering the consumer's right to take legal action or exercise any other legal remedy by requiring the consumer to take disputes exclusively to arbitration, not covered by legal provisions. Now, if I just pause briefly, the words not covered by legal provisions refer to forms of statutory arbitration. So it's a carve-out for where there is specific legislation which requires someone to go to arbitration. There are some types of specific statutory forms of arbitration. But absent a case like that, what is on the list is any case which requires a consumer to take disputes exclusively to arbitration. Now, the CMA skeleton also addresses this in some detail at paragraphs 9 to 18.
You say that because of the first instance decisions that have suggested that. But this is a carve-out. Perhaps that's the wrong word. What's being addressed is a term which has the object or effect of excluding or hindering the consumer's right to take legal action or exercise a legal remedy. And then this is a particular example requiring the consumer to take disputes exclusive to arbitration, not covered by legal provisions.
Yes.
And just looking at it, the carve-out of not covered by legal provisions, you might have thought, was harking back to the question of whether the arbitration did exclude or hinder the consumer's right to exercise legal remedies, not confined to statutory arbitration.
Well, the better view in my respectful submission is this refers to compulsory arbitration in certain spheres.
But I'm asking you why you submit that.
Well, because it makes perfect sense, because it's directed at contracts, and it's saying that anything that requires a consumer to take disputes exclusively to arbitration is an unfair term, or can be an unfair term, where that arbitration is not covered by legal provisions. It's not within the framework of some statute for specific types of disputes to be taken to certain arbitral tribunals.
Is your submission because all forms of statutory arbitration have built within them procedural safeguards for the fairness of consumers? Is that the submission?
My submission is, because they are statutory arbitration, they've been considered by Parliament to be a fair way of resolving the dispute.
For consumers?
For whoever is subject to them. And that is why Parliament has enacted them. And that is why it makes perfect sense for this to be a carve-out.
I understand the structure of this. This is a provision in a grey list.
Yes.
There are terms which may not be even on the grey list at all, which the court could still find were unfair.
Correct.
So the fact it's in this list doesn't mean it has to get onto this list in the first place before it could be found to be unfair.
That's right.
So this is a way of, as a leg up,
Yes.
essentially, saying what's being defined here is a set of terms which may not be unfair themselves either, but they're at least in the frame for saying you should take a look at it.
Yes, that's right. And that's why, although the list is headed at the top, may be considered unfair, the word may is used, the commentators tend to say that something is on this list is presumptively unfair. I mean, it may be putting it too high, but it's the leg up. you're going down the right direction. You're going down the direction of unfairness simply by being on this list because of the nature of the clause. And if you look through maybe we should look just briefly through what the other clauses are on the list. It's page 33, starts on page 32 in the Court of Authorities bundle. So on page 32, consumer contract terms which may be regarded as unfair, as I said. But you start with, for example, number 1, a term which has the object or effect of excluding or limiting the trader's liability in the event of death or personal injury to the consumer resulting from an act or omission of the trader. And it goes down through a number of situations, nothing to do with dispute resolution, most of them. And then 20, which was Q in the previous regulations. The term which has the object or effect of excluding or hindering the consumer's right to take legal action or exercise any other legal remedy, in particular by requiring the consumer to take disputes exclusively to arbitration. Now, as I say, that was considered in a detailed review of the authorities by Mr. Justice Ramsey in the Milchrist Builders case, and he summarised the principle. We've suggested it's a useful summary at paragraph 51 in his judgment. So that's and 11 Court Bundle of Authorities. He was dealing with the earlier regulations. You can see that on page 300, and he refers to the House of Lords decision in Director General of Fair Trading at paragraph 43. Cites various passages from the judgments of their lordships, and then refers to the Court of Appeal decision in Bryan and Langley, that's paragraph 50 on page 302. And then he says, from these authorities, the following principles can be derived in relation to the application of what were then the 1999 regulations, but are now the Consumer Rights Act. I won't read all of that out, it's a sidelined passage there. And we say then that approach is consistent with the Supreme Court decision on fair and unfair terms in the Cavendish Square case. And we've set out more detail of the skeleton argument. I won't read out all of these points, but we've set them all out. Subparagraphs 1, 2 on page 19, and then over the page, a series of points as to why it should be regarded as not binding, and then we separately deal in subparagraph 3 on page 21 with the requirement of good faith and open and fair dealing, which has been explained also by the Supreme Court in Cavendish. So, I don't want to spend time just reading these points out, but that in my respectful submission, there's an extremely strong argument, and it's one that can be summarily determined in the circumstances. And we were interested to note that the CMA agree with that, and their skeleton, for example, at paragraph 32, I'll just show you their skeleton. Points out that arbitration clauses where the value is less than 5,000 are on the blacklist. And then 32.2, such clauses create particular and significant detrimental imbalance in that they waive a consumer's right of access to their own courts, require any dispute to be arbitrated, and any such imbalance is exacerbated if the seat of the arbitration is outside the consumer's jurisdiction and within the trader's jurisdiction, and the arbitration is governed by the lex loci rather than English law. Such terms are contrary to requirements of good faith if they are imposed on consumers via an online process without any explanation and or opportunity to negotiate. Their effect was not specifically drawn to the attention of the consumers, and it's reasonable to assume that consumers would not have agreed to them in individual negotiations. And that is all entirely consistent with the original intention of the EU directive, from which the Consumer Rights Act provisions are ultimately derived. And if I could invite you, please, to look in the supplemental authorities at tab 9, one of the early cases, Oceano Gruppo, judgment of the court in 2000. And it was dealing with, if you look at paragraph 3, first of all, on page 111, purpose of the directive, from which this all came, is to approximate the laws, regulations, and administrative provisions of the member states relating to unfair terms in contracts concluded between a seller or supplier and a consumer. And then Article 3.1 of the directive provided, this is on page 112 near the bottom, contractual term which has not been individually negotiated shall be regarded as unfair, contrary to the requirement of good faith. It causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. And then on page 113, you can see what was then Q, excluding or hindering the consumer's right to take legal action or exercise any other legal remedy. And I won't go through all of this, but it's very brief, the reasoning. And at paragraph 22, which is on page 117, it says, a term of this kind, the purpose of which is to confer jurisdiction in respect of all disputes arising under the contract on the court in the territorial jurisdiction of which the seller or supplier has his principal place of business, obliges the consumer to submit to the exclusive jurisdiction of a court which may be a long way from his domicile, makes it difficult for him to enter an appearance. In case of disputes concerning limited amounts of money, the cost relating to the consumer's entering an appearance could be a deterrent, forcing him to forego any legal remedy or defence. Such a term thus falls within the category of terms which have the object or effect of excluding or hindering the consumer's right to take legal action. Category referred to in subparagraph Q, which is now 20. And by contrast, the term enables the seller or supplier to deal with all the litigation relating to his trade, business or profession in the court in the jurisdiction of which he has his principal place of business. Makes it easier for the seller or supplier to arrange to enter an appearance, makes it less onerous for him to do so. It follows that where a jurisdiction clause is included, without being individually negotiated, in a contract between a consumer and a seller or supplier within the meaning of the directive, and where it confers exclusive jurisdiction on a court in the territorial jurisdiction of which the seller or the supplier has his principal place of business, it must be regarded as unfair within the meaning of Article 3, insofar as it causes, contrary to the requirement of good faith, a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. Now, it is not a unduly complicated or detailed analysis that's required in order to decide that there is unfairness. The whole point is that one's deciding these things.
So everybody knows that encyclopedias don't actually cost that much, and you might be having to travel to litigate. So what assumptions do we make about the cost of NFTs bought on this particular platform? I mean, how much do they cost? £650,000 a piece?
No.
More?
No. I think a lot. I mean, many cost a lot less. And I can take specific instructions on that. But I think what many may cost £100 or two. I don't know. But I will need to take instructions on that. But they can the whole range of different values, I think, is the answer. But I will.
So I mean, I'm sorry. I was pushing back at the.
Yeah.
I mean, we know I assume that at least two people bid more than £650,000.
Yes, we do. We do know that.
But dollars, perhaps, or maybe it's the same these days.
Well, it's more complicated because it's in Ethereum, I think, but it's translated into dollars.
Yeah. Okay. So, but what assumption are we? I mean, value seems to the value of the transactions seems to be, for example, in this particular case, a relevant factor.
Yeah.
If you're buying a few encyclopedias, you shouldn't be expected to have to travel to where the manufacturer or the vendor of the encyclopedia. I think these are encyclopedias, weren't they? Purchased by instalments of an encyclopedia for personal use.
Yeah. Well, my lord, let me take instructions on the size of transactions for NFTs. My very much my own general understanding, but I'm not.
I'm trying to sort of point out that this is
that one can. There are a whole range of values.
Not quite as straightforward in factual terms. Not easily capable of being resolved just by saying, well, you just take an objective view.
Well, okay. Yeah, I understand that point.
Whilst we're on travel, I noticed that in the JAM's policy for consumer arbitration, there is a provision. Am I right in understanding that at the moment it's as yet unresolved as to whether Judge Katz will or won't apply those terms?
That is, I believe, the case. I think there was an early indication that he might, and then I think it's now an open question.
Because I noticed that there was a provision which says that the consumer is entitled to an in-person hearing in his or her hometown. Is that a right that your client has invoked in the arbitration?
Well, no, not yet, because.
But if so, for example, then the travel consideration wouldn't be something that wouldn't come into consideration here.
Well, if those rules do apply.
Yeah.
Yeah, which I would think hasn't yet been ascertained.
Well, presumably you'd have to fly the arbitrator.
Well, somebody would have to pay the cost of that, yes. I don't suppose the arbitrator would do it for free.
But whether ultimately the consumer who might have to bear the costs if he loses would end up paying more for an arbitration than he would for litigation is not necessarily a question which has an obvious answer, is it? I know the court fees might be more modest, but if there's an exposure to paying the other side's costs, which there would be both in arbitration and for Mr. Soleymani in litigation here, again, it doesn't seem to me to be obvious that we can decide, for example, that it's disadvantageous for it to be dealt with in arbitration rather than litigation.
Yeah. But the main disadvantage, I don't want to repeat too much this morning, is that these rights don't exist under New York law, and they only exist in this court. Therefore, substantively, the position is different. And that's true of the Gambling Act point as well, by the way. So substantively, the position is different. And that's why my client wants to establish that the arbitration agreement is not valid as a matter of English law.
But am I right in understanding that so far... Sorry to interrupt you.
Yeah.
Am I right in understanding that so far the arbitrator has said it's an open question as to whether he will or won't apply English law?
Yes, but if you look at what he's actually said, and I was going to take you to this, it's pretty clear he's not going to. But he has invited submissions on the point. But he's already held. I mean, he says things like English law, if applicable, or if relevant, and then we'll see in a moment. But he's already held that he can't see the relevance of English law on the jurisdiction issue, for example.
But you're asking us to say now that the arbitrator won't apply English law.
Well, it's hard to
a
see
matter of
why
summary decision, and that's one of the aspects that makes this arbitration agreement unfair. You're saying.
Well, he won't apply it in the way that this court does as mandatorily applicable, because it is not mandatorily applicable in any forum other than the English court. So that's point one.
But hold on.
Point two.
Sorry.
Yeah.
Does it matter whether he applies it as mandatorily applicable or not if he is going to apply it?
Well, in my respectful submission, it's fanciful to suggest that he's going to apply it, but being realistic, because maybe I should show you his reasoning already, but I wasn't going to come to it in a minute. But he has already said that it's got no relevance to his decision on jurisdiction.
I mean, you say that. Do you say the consumer just shouldn't have to face the risk? I mean, that's the significant imbalance. I mean, how do you actually put? I mean, I'm just wondering whether we need to go this far. I mean, your point is that the consumer shouldn't be put at risk in an arbitration of non-application of the provisions of the Consumer Rights Act. Is that the point?
Yes. Well, very, very substantial and very real risk, because, and I'll show you the reasoning he's given in a moment on the jurisdiction application. But what was argued to him was under English law, the arbitration agreement is invalid, and therefore you don't have jurisdiction. And he held that English law was irrelevant on that point. So he has already made a provisional ruling. I believe that it's like a lot of things in America, you can make a ruling, but you can still revisit the ruling at a later stage. But his provisional ruling he made last December was that he had jurisdiction, and the objections based on English law to his jurisdiction were of no foundation and not relevant. Shall I take you to that, as we've got onto that? It's tab. It's tab 10 in the supplemental. No, sorry, tab 11, the supplemental bundle. So if we start at page 100. This was his ruling in December, I think. He says, respondent, it's about 5 lines down on page 100, respondent argues, among other things, there's no valid agreement to arbitrate the dispute in issue. The party's dispute is presently pending before the High Court in England. And 3, the arbitration provision upon which this forum's jurisdiction is based contains terms that are contrary to English consumer rights law and the JAM's policy on consumer arbitration. And he says...
Is it really at page 114?
Well,
respondent hasn't demonstrated the arbitral forum lacks jurisdiction.
No, it's before that.
Him having said that he's got competence, as it were, and then he goes on to say virtually all of the other arguments relating to the validity of the arbitration provisions and whether he's bound by them can't properly be resolved on the instant motion.
I think it's earlier than that, my lord. I was going to show you passages earlier on that, but it culminates in 112. He refers to the arguments on 107, and then at the top of 108 he says the only question to be resolved is whether the other arbitrator has jurisdiction to resolve these issues. And the answer to that question is clear, he does. Then he refers to the the very pro-consumer arbitration approach in America. He says the transaction at issue is undoubtedly a transaction involving commerce. It's governed by the Federal Arbitration Act, which provides that a written arbitration agreement contained in a transaction involving commerce shall be valid and enforceable, save upon such grounds as exist at law and equity for the revocation of the contract. So that's the sort of unregulated arbitration approach in American law, which is perfectly standard. But for your help, my lord, we've put in a couple of academic articles which compare and contrast the English law position, the EU and English law position, with the US position under the Federal Arbitration Act. I don't know if you've managed to get to those, but I would say that they are of some interest and relevance. They are totally consistent with what he has said there. And then if we go on, he considers those arguments.
Well, as I read it, what mattered to his decision was, as he says at the bottom of 108, whereas here an arbitration provision so provides, it's for the arbitrator to decide jurisdictional issues and the scope, applicability and enforceability of the arbitration provision, i.e. competence, as we put it.
My lord, he does deal specifically with the English law point, and that's what I want to show you in 112.
Yes.
He says on 112, the only truly jurisdictional argument the respondent passes is that as a British citizen, he has the right to have an English court determine, under English consumer laws, the issues in contention between the parties. But he provides no legal support for his position. Claimant aptly notes, by agreeing to the Nifty terms, must be accepted as true. Respondent agreed that his activity on the Nifty platform, including his participation in Nifty auctions, took place in New York. Moreover, he consented to arbitration in New York and to New York law governing the terms of use applicable to the platform. And he says, under these circumstances, ample evidence to conclude the respondent consented to and engaged in activity establishing the jurisdiction of this arbitral forum by agreeing to arbitrate in New York, where the United States Arbitration Act makes such agreements specifically enforceable. Commissaire General must be deemed to have consented to the jurisdiction of the court. So, although the English law arguments were raised, he says there was no support for them being relevant. That's at the top of page 112, and he referred instead to the choice of law clause, which is one of the things that we're seeking to have invalidated by the second head of our claim. So, my lord, in those circumstances, it is true that he has subsequently given a direction that the parties should make submissions to him on the applicable law. That was in his directions in June, which we also have in the bundle at page 122 to 123. But it seems unrealistic, in my respectful submission, given the tone in which he's expressed himself there, that he's going to apply English law to anything before him.
Why is it?
I mean, obviously my client's in an invidious position because they're trying to persuade him, if the arbitration goes ahead, that he should apply English law, because that's where they get their protection from. That's where my client gets his protection from. But looking at that and the way he's expressed himself, it does seem unlikely that he's going to recant and say that the choice of New York law is overridden by revisions of English law, which he said, in effect, had no relevance to the dispute. So that's what's at stake in this case, my lord. I mean, if it goes ahead here, my client gets the protection of these provisions. But if it doesn't go ahead here, it's going to be all decided on the basis of freedom of contract and New York law. So that's what, and that's why an English court, when faced with a claim where someone is relying on their mandatory rights under English law, is bound to give effect to those rights, in my respectful submission. Just as the House of Lords did when it invalidated the jurisdiction clause in the Hollandia. It wasn't even a case of we had any sort of protection against jurisdiction clause. It was a case based on the substantive protection given by the Carriage of Goods by Sea Act, but nevertheless held you couldn't compel the cargo claimant to go to another jurisdiction where they would recover less money than they would under the Carriage of Goods by Sea Act. They'd get less, their rights would be diminished by going to the foreign jurisdiction. Therefore, the House of Lords held that the jurisdiction clause was struck down by the Carriage of Goods by Sea Act. And that's what a mandatory law does. I mean, when a point of mandatory law comes before the English court, just as Lord Justice Tuckey in the Semengo Turner, there's no choice but to give effect to the intention of Parliament by whatever means are available to the English court in relation to the issues that are presented to it. So we respectfully submit, my lord, that there is a strong case of unfairness. I haven't taken you through paragraph by paragraph, either my skeleton or my learned friend, Mr. Riley Smith's skeleton, but I do urge you to go through those paragraphs that I've identified and to make a clear finding whether you apply a wholly objective test or a partly objective, partly subjective test. This is clearly an unfair term in the circumstances. So there's no need for this matter to be referred off to an expedited trial. My client would be quite happy to do whatever was necessary to have an expedited trial before the 13th of September, he tells me. But it is not necessary. This court can and should grasp the nettle now and determine the matter now that it is unfair for all the reasons that are set out in the two skeleton arguments. And that leads me to the third head of my submissions, which is how, in respect of these mandatory provisions, it is vital that the English court takes a view and doesn't delegate the decision to a foreign tribunal. And I would go so far as to say that in light of what I'm about to show you, it is contrary to public policy, which is embodied in the consumer protection provisions, for an English court to not decide an issue of fairness under the Consumer Rights Act and to send that issue off to be decided by a private arbitration tribunal, even assuming, arguendo, that private arbitration tribunal is going to apply the Consumer Rights Act, which in my respectful submission is fanciful in this particular case.
Just on that point, I'm just trying to get my head around section 62(5) of the Consumer Rights Act.
Yes.
It says that when you're determining whether a term is fair, you take into account the nature of the subject matter and you refer to the circumstances existing when the term was agreed. How is it? How does the fact that an arbitrator might or might not purport to apply English law fit? I mean, is it that you say, I think, is it that if there's a risk that an arbitrator might not apply English law or couldn't, that's enough to create a significant imbalance? And you can't have to sort of judge whether a term is fair on a wait-and-see basis.
No, I think
I think this. I mean, I'm.
Yeah. I think the question of whether there's significant imbalance is normally determined by asking whether the person would have agreed it.
Yes.
If they've been given the opportunity to agree it or not agree it.
So by definition, I think as I put to you a little while ago, I mean, what you're really complaining about here is the risk that an arbitrator might not apply what you say are the mandatory provisions of English law about unfair terms in consumer contracts. If there's,
Yes.
if you can't guarantee it, if there's a risk,
certainly the risk.
then
but
that's the significant.
Yes.
Is that the way your argument is best put?
I'm with you. But it's just that I don't want to diminish it by agreeing the risk. I would say the very substantial risk or something like that. But yes, I agree. That is one way that's put. I mean, I think it's more than a risk. You're being sent to a forum where, under clause 16, it is expressly stated that the dispute will be governed by New York law.
Without regard to conflict.
Without regard to conflict of laws, as
So-
if the contract was made and wholly performed in New York. So it's not a risk. It's a. And obviously, I don't want to sabotage whatever submissions we might make to the arbitrator in the unlikely event that he might accept that. But it does seem unlikely, given the way that he's also already expressed himself, that he's going to do it. And looking at I know you want to look at the matter as at the time when you agree. And
I'm not saying I do. I'm just saying I do. I'm not saying I do. I'm just looking at section 62.5 and trying to figure out in my head
that is
how
the
it
right
works.
test.
And is it relevant to ask whether New York law is more or less favourable to Mr. Soleymani than English law?
Well,
Suppose hypothetically that he's better off under New York law. Would that be something, therefore, which would make that term unfair?
the
governing law
the arbitration clause, or
the governing law clause.
Sorry.
Well, both. The same issue.
So the hypothetical discussion
Yes.
that the statute or the cases suggest you need to have, would the person have agreed to this term if it had been the subject of individual negotiation, which is broadly speaking, I think, the test. The sort of dialogue would have gone along the lines of, well, Mr. Soleymani, you're going to agree to arbitrate any disputes in New York. The first question you might well ask is, okay, well, who's the arbitrator? Second question is, which law is he applying, and is it better or worse for me?
Yeah. Well,
But
certainly,
as to
if
which
it
we
was the
have very
case,
little, if any, material.
but if it were the case that it was an obviously better place for consumers, I think that would be a relevant consideration. My point is, looking at this as a realistic lawyer, it says arbitration in New York without regard to anything other than English law, New York law.
Well, that's true, but we also know that there's something called the JAMS policy for consumers,
But if
which it purports to protect consumers in such arbitrations. Whether it's effective to do so or not, I have absolutely no idea. But
it doesn't
aren't
provide any
those questions
substantive protection. They're all procedural matters.
right.
I was going to come to this, but it doesn't have any substantive protection. It doesn't invalidate any terms or anything like that. It's simply procedural way of treating
Well,
consumers.
I understand that.
Under the Federal Arbitration Act, and this is dealt with in those two academic articles, in contradistinction to the position in EU and English law, consumer arbitration agreements are regarded as just normal arbitration agreements. There's no special protection under the Federal Arbitration Act in respect of consumer arbitration agreements. So if it was procured by fraud or something like that, then you can say it's procured by fraud. But there's no consumer protection in relation to arbitration in the United States, such as compared to what there is in England. And if I just give you the reference to those two articles. They are at tabs 12 and 13 of the supplemental bundles of authorities. There's an article at tab 12 by someone called Hornley, who examines, first of all, consumer protection under English law in relation to arbitration clauses, and then contrasts the position with United States law under the Federal Arbitration Act, and concludes, page 153, that there's a presumption in the US that consumer arbitration clauses are enforceable. There's no regulation. There's no equivalent to the regulation that we have in England. And then tab 13, which is an article by, I think, a professor at Leicester University and another academic there, which contrasts commercial arbitration and consumer arbitration. And then it discusses what it calls the regulatory freedom approach under US law, and contrasts that with the regulatory control approach under EU and UK law. And that's, first of all, pages 157 to 159, and page 165. And what you will find in those two articles is that aligns perfectly with what the arbitrator has said on page 108 that we were looking at, where he refers to the Federal Arbitration Act. They say that any doubts as to arbitrability under the Federal Arbitration Act have to be resolved in favour of arbitration. There's no consumer protection under the Federal Arbitration Act. So that is the why this is such a stark choice, and this is why all these platforms are choosing New York law and New York arbitration, because there is no consumer protection in that arbitration. So that's the choice that the court is faced with. Now, the next part of my submissions, my lord, is that the English court, as indeed it would have been the case when we were in the EU, under EU authorities, but now specifically under Section 71 of the Consumer Rights Act, must, because these are mandatory laws, it must look at this issue and decide upon it. Now, there was a series of EU cases on this. I've already shown you the earlier one, the Gruppo, Oceano Gruppo one, but very briefly, tab 15 in the core bundle authorities, the Mostaza Claro case. This is about an arbitration clause in a mobile phone contract, and I would urge you to read.
Sorry, I was making a note. Just give me the reference again.
Yeah.
Where are we?
We are in the core bundle authorities, tab 15, Mostaza Claro. And the head note, page 408, a national court seized of an action for annulment of an arbitration award had to determine whether the arbitration agreement was void and annul the award where that agreement contained an unfair term, even if the consumer had not pleaded that invalidity in the arbitration proceeding, had only done so in the action for annulment. And the relevant paragraphs, quite lengthy actually, starting on page 422 and running to 424, dealing with the nature of the consumer protection and the importance of the national court making a decision as to whether or not the term is unfair when the matter comes before it. And there's been a line of authority. Then there's at tab 16, there's the Panon case, which I think was referred to in my learned friend Riley Smith's skeleton argument. And one sees, this is again another telephone contract with a jurisdiction clause in this instance. And at 435, paragraph 25, the court emphasised, and pick it up about 6 lines down, that Article 6.1 of the directive is a mandatory provision which, taking into account the weaker position of one of the parties' contract, aims to replace the formal balance which the latter establishes between the rights and obligations of the parties with an effective balance which re-establishes equality between them. And then if you go over, we've sidelined various passages, but I was going to emphasise paragraph 32. The court sees that the action is therefore required to ensure the effectiveness of the protection intended to be given by the provisions of the directive. Consequently, the role thus attributed to the national court by community law in this area is not limited to a mere power to rule on the possible unfairness of a contractual term, but also consists of the obligation to examine that issue of its own motion, where it has available to it the legal and factual elements necessary for that task, including when it is assessing whether it has territorial jurisdiction. That's one of the passages I rely on in relation to that point. And then there's another phone case with an arbitration clause, which is at tab 17. And the relevant paragraphs are sidelined, page 445 to 446, where again it's said at paragraph 32, the court is therefore held that the national court is required to assess of its own motion whether a contractual term is unfair. And then again, the sideline passages on pages 447 to 448, they point out at 51 that Article 6 is a mandatory provision. And then at 53, follows from this that inasmuch as the national court or tribunal sees an action for enforcement of a final arbitration is required in accordance with domestic rules to assess of its own motion whether an arbitration clause is in conflict with domestic rules and public policy, it's also obliged to assess of its own notion whether that clause is unfair in the light of Article 6 of that directive, where it has available to it the legal and factual elements necessary for the task. And that stress on the mandatory nature of these provisions and the requirement that because of the mandatory nature of the provisions, the court must assess the matter when it comes before it, led to this being embodied in the English statute, which is section 71 of the CRA, which is in tab 1B at page 30.
Was the judge taken to those three cases or just to the statute?
I don't think
They're cited before the judge?
No, I don't think she was. I'm told by my learned junior that she did cite section 71 to the learned judge, but it didn't seem to have a lot of impact, something to that effect. But it is, in my respectful submission, a very, very important provision. Because section 71 is our English statutory embodiment of the principles in those cases, and the sidelined passages. Duty of the court to consider the fairness of a term. Subsection 2 applies to proceedings before a court which relate to a term of a consumer contract. The court must consider whether the term is fair, even if none of the parties to the proceedings has raised that issue or indicated that it intends to raise that issue. If it doesn't apply, the court considers that it has before it, unless the court considers it has before it sufficient legal and factual material to enable it to consider the fairness of the term. Now, this is why the approach that the learned judge took to section 9.4 in particular, but also to jurisdiction, was wrong, because the court must consider the fairness of the term, provided there's sufficient legal and factual material to enable it to consider the fairness. Even if the court considers that there might be some factual material which is missing, it doesn't mean, in my respectful submission, that you send it off to be decided by an arbitrator. Still less who's already decided that he can't see the relevance of English law. Because you're just sending it off to, you're just dooming the point to do that. But this is what makes this case so different from the normal case under section 9.4. Because the normal case under section 9.4, as was discussed in the burrito, there might be various reasons why the court should decide the point or not decide the point, but leave it to be decided by the arbitrator. But in this context, the Consumer Rights Act says that the court must consider the point and must consider whether the claim is fair. In this context, I was going to make three further points, so I think I've probably made them, but I'll just mention what they are. First of all, that Article 12 of the recitals in the regulation make it clear that there's nothing which stops a court from deciding that an arbitration clause is invalid under its own applicable law. Its own applicable law. I did read that out earlier, so I won't read it again. Secondly, the approach that I've urged on the court is exactly the approach that was followed by the German court in Zellner. I've taken you to that case. And thirdly, although we haven't looked at this, we've looked at some cases that refer to it, under the New York Convention, there is nothing which prevents the courts of a state, which is party to the New York Convention, from deciding that an arbitration agreement is invalid under its own law. We saw it set out in the West Tankers case, Article 2, Roman 2, paragraph 3 of the New York Convention, which is page 60 of the core bundle, that the court can decide whether a clause is void or ineffective. And in Article 5, paragraph 2, there is an express saving on enforcement for public policy matters. So that leads into the fourth part of my submissions as to why on section 9.4 the court ought to have either decided the point or referred the matter off to be decided by a trial in the court. And I think there are probably 5 reasons why we submit that the learned judge's reasoning on this part of the case is wrong. The first is the point that I've just been making, that section 71.2 says that the issue of fairness, when it arises in the English court, should be assessed and determined by the English court. And that none of the leading cases, which we have in the bundles on section 9.4, that's the Al-Naimi, tab 3 of the supplemental bundle of authorities, Aeroflot and Berezovsky, which is the core authorities, tab 13, or the Burrito, which is tab 12 of the core authorities. In none of those cases was there anything equivalent to the statutory duty under section 71.2, where the court itself has to decide the disputed issue of validity by reason of some other piece of legislation. So we respectfully submit that section 71.2 is a special and unique feature which hasn't existed in any of the existing case law on section 9.4. And in combination with the Civil Jurisdiction and Judgments Act 15b 2 and 3, it gives a UK domiciled consumer a prima facie right to have the English court rule on the matter. Now, the learned judge said this in paragraph 113. She said that the only matter connecting England and the dispute under section 9.4 was that the claimant was resident in England. Well, that is, in my respectful submission, an entirely sufficient fact to require the English court to decide the matter. And really, that the fact that she says that was the only connecting matter with 9.4 and England was that the claimant was domiciled or resident here, really shows that she hadn't grasped the importance of section 71, subsection 2. What the judge did instead was to carry out a conventional forum convenience type analysis, which we say, in the consumer context, and bearing in mind section 71, is inappropriate, because she should have started from and given paramount weight to the domicile of the appellant, and his therefore prima facie right to have the unfairness issue decided by his home court. that's the first error in my respectful submission, the learned judge's judgment. The second error is the unfairness of her decision, because her decision in imposing a stay and sending the question of the validity of the arbitration agreement to be determined by the arbitrator, who had in fact already determined that he had jurisdiction and that English law was not relevant to that issue, is tantamount to a denial of the claimant's mandatory English law consumer protection. The reasons that I've gone through already this afternoon. And the only way that this court can give full and proper effect to that mandatory protection under English law is by deciding for itself at the outset of the proceedings whether the arbitration clause is invalid or not. The reasons we say that, I've been through many of these before, and I'll take them quite quickly. If the matter is determined in an English court, the consumer protection laws are mandatory, but in the New York arbitration they are not. In the New York arbitration, the arbitrator is likely to apply the choice of law clause in accordance with its express terms, without regard to conflicts of laws principles, and so forth. And I've shown you his reasoning in relation to that. That is consistent with the academic articles at tabs 12 and 13, to which I've already referred. There is, of course, the question that Lord Justice Popplewell put to me, that the arbitrator may treat this as a consumer arbitration under the JAMS rules. That, by the way, those rules, you may have looked at them, are in tab 25 of the core authorities. But they are neither here nor there so far as substantive protection is concerned, because they are essentially procedural rules that do not afford substantive protection. And there is no evidence that under the federal law of the United States or under New York law, there is any substantive protection to consumers in a case like this. On the contrary, the articles by the two academics that I've referred to suggest that there isn't. And then the learned judge said this in relation to this area. She says, there is no evidence, this is paragraph 112, she says, there is no evidence to suggest that the arguments of English law could not be raised in the arbitration. Well, that's not really any consolation. No doubt they could be raised in the arbitration, but for the reasons I've explained, they're most likely not going to succeed, and they haven't succeeded so far in persuading the arbitrator that he should decide the jurisdiction issue in accordance with English law. So really what is at stake is this consumer, someone who's admittedly a consumer for the purpose of this application, to be given the benefit of his mandatory consumer protection in the English court, or will dispute be sent to New York where he doesn't have the benefit of that protection. And then the judge said this at paragraph 115. The questions of consumer protection raised by the claimant are not matters that can only be adjudicated upon by an English court. Well, again, with great respect to the judge, it would be far more realistic to say that they can only be adjudicated upon by the English court, because it's only in the English court that these protection laws are mandatory, and there's not a shred of evidence, and certainly no realistic indication that the New York arbitrator will apply any aspect of English law, let alone the consumer protection laws. And really this comes back to the point that the whole decision by the judge at first instance is vitiated by a failure to recognise that the mandatory rules of consumer protection are only mandatory in an English court, and therefore as soon as a dispute is referred to a foreign arbitration under a different governing law, it is likely that the protection of those mandatory rules is lost. Now, the reason why the EU and Parliament have enacted this consumer protection is that they want consumers to have the benefit of these rules. And the only place where the consumer will necessarily get the benefit is before their own national courts. The third reason we say that the learned judge followed the wrong approach is in paragraph 109. In the beginning of paragraph 109, she correctly recognised that the English courts would be better placed to decide questions of English consumer law. But then at the end of the paragraph, she discounted this factor by saying that the English court could not be said to be significantly better placed. Now, we respectfully submit this is wrong. Even if we assume, which I have submitted is somewhat fanciful, that the New York arbitrator will apply English law, the English court is obviously far better placed to apply English law than the arbitrator is. The questions of fairness under the CRA, questions of EU and English law, there's a body of English and EU case law, and the English court is far better placed to decide those questions. If the arbitrator were to change tack and decide he will apply English law, he will require expert evidence, and he will have to choose between the evidence, presumably, of two competing experts. There will be no appeal against the decision of the arbitrator on English law, and this factor, in my submission, favours the matter being dealt with by the English courts. Although, as I said earlier, there's no real indication that the arbitrator in New York would apply English law anyway. The fourth point is that the New York arbitration forces the appellant...
Do the GEMS procedural rules provide for no right of appeal, both the consumer ones and the substantive ones?
I'll check that. Certainly, it would normally be the case. There's no right.
I thought that was the point you were making. There couldn't be an appeal against it.
I'll have to look. If the GEMS rules are applied, we'll have to look and see what they say about that. Yeah.
Clause 17 says that the award of the arbitrator is final and binding.
Yes.
I don't know whether that's quite the same point.
No, it's not entirely, because all arbitration clauses provide that. But some nevertheless, for example, in England, give a right of appeal in limited maritime contexts and some other contexts. Now, the fourth point is that this is a foreign arbitration under foreign law, forcing a person who's got no connection with the United States to go to arbitrate there. And the fifth point is that another error in the judge's reading...
I'm so sorry, I was looking at something. The fourth point was what?
Another error in the judge's reasoning, the fifth point... is that
I missed the fourth point.
The fifth point was...
Fourth point.
The fourth point is that the New York arbitration forces the appellant to arbitrate in New York under New York law, a jurisdiction with which he has no connection, in which he's not domiciled, and even if he was a US citizen, for example, if he's domiciled in the United Kingdom, then forcing him to go to a place other than where he domiciled violates the principles discussed in the Oceano Gruppo case as far back as 2000. The fifth point is that another error in the judge's reasoning, which is paragraph 100...
Is the corollary of the fourth point that, just trying to look at it from the other perspective, that the vendor, Nifty, you say has, on the hypothesis we're all working on, directed advertisements or directed its business to the UK, and therefore can't be said to be in the equivalent position to Mr. Soleymani. that it only operates in New York, but on the other hand, it has chosen to extend its business
Yes.
abroad. So that's
Yes, and as I mentioned,
is that is that a relevant factor for purposes of Section 9?
I'm not. Well, it's certainly it could be under Section 9.4 if one is doing what I would call a conventional forum convenience type analysis. It could be.
You're not at this stage dealing with whether the term is or isn't unfair.
No, I'm
You're
not.
dealing with the question as to whether it's right to let that be decided by the New York tribunal.
Yes.
Yeah, but your point you were making was that it's. I think I wrote it down that it's the judge was wrong to force somebody with no connection to the United States to go to participate in an arbitration there.
Yeah.
That's part of your argument to say actually there should be a determination by the English court.
Yes, it is.
Of this, and so I was just trying to think of the converse.
The converse. Well, according to the deposition evidence last week, not only has Nifty directed itself to people in the UK, but it's been quite successful. It's got 100,000, 200,000 people who've come onto its website and are either our consumers or our potential consumers. So I would certainly say that it has, and it's one of its three biggest markets. Was the evidence that was given in the deposition. The US, Canada, and the UK were the three biggest markets for the 1 million to 2 million people that they have on their platform. So, but I mean, I'm simply trying to, yes, this is a factor that the judge didn't take into account. The fifth point is another factor which the judge did take into account in paragraph 107, where she said there would be overlapping issues being determined both in the court proceedings and in the New York arbitration. Now, we respectfully submit that this is a factor which is either totally irrelevant or doesn't bear much weight. Because on the one hand, there is the statutory right to proceed and have the matter determined in England under section 71(2). If the English action proceeds after there's been a determination on the validity of the arbitration agreement by the English court, it will be open to the respondent to advance all its claims by way of counterclaim in the English action. And from an English law perspective, that is what it should have done from the outset, because it should have respected the claimant's rights. So as a matter of English law, which is mandatory in this court is bound to apply, the respondent's claim should have been brought here in the first place. We also believe that there is a prospect that if this court decides, or any English court decides, that the arbitration agreement is not valid as a matter of English law, that the arbitrator will respect and abide by that reading, or certainly it would be our submission to him that he should do so. And we may well seek at that point an anti-arbitration injunction to prevent the arbitration going forward. So we don't accept the premise in the judge's reasoning at paragraph 107 that there will be overlapping issues being determined in both sets of court proceedings. And as I said earlier this morning, and I've confirmed this on instructions over the short adjournment, my client's perfectly happy for all the substantive issues to be brought into the English proceedings if we win on these points, and to amend his pleadings to bring everything in, and then there will be no need for any overlapping proceedings, because the arbitration can be discontinued and all the proceedings can be decided in the right place.
Is that an offer of an undertaking? And if so, I think we'd better see it in writing.
Yeah, I think it is.
And if it isn't, should we take any notice of it?
It is an offer of an undertaking. We can put it in writing. So we will attend to that overnight. I do have express instructions on that. So if I may sum up, on section 9.4. The judge held that there were some strong arguments that the arbitration clause was unfair and not binding. That's paragraph 105 of the judgment. For the reasons that we've given, we say that the judge should have gone further and that she had sufficient material before her to decide whether the arbitration clause was unfair and not binding or not, and she should have decided it was unfair. And indeed, under section 71, subsection 2, the court is required to decide it. And if the court looks at the first instance decisions that have been made in relation to unfairness of arbitration, and I'm just going to briefly mention these. The Picardy case at tab 6, the core authorities, the Milchrist case at tab 11 of the core authorities, Zeelander case at tab 2, and the Standard Bank case at tab 4 of the supplemental authorities. In each of those cases, the judges in question found that the arbitration clause, fairness or unfairness, could be determined in only a few paragraphs. For example, in the Picardy case, it's 4 paragraphs from 128 to 131. In Milchrist, it was determined in 4 paragraphs. In Zeelander, it was just over a page. And in Standard Bank case, it was 5 paragraphs. It's not a length properly done. This is not a lengthy or detailed factual inquiry because it doesn't go into subjective matters. And we say that the learned judge could and should deal with the fairness issue on the material available to her, summarily and briefly, and so can this court. And if she had done so, she would have found that section 9.4 applied, and she would and should have refused to stay. And we understand that the CMA support the claimant on this position, and the CMA skeleton says that there was sufficient material before the court for it to make a determination on this issue. That is in paragraph 34 of the CMA skeleton, where they say the court in this case, like the judges in the cases highlighted in paragraphs 21 and 22 above, had sufficient legal and factual material to decide the issue. And so that is our primary submission in relation to section 9.4. But if this court were to think that it couldn't decide the matter, then we would say that it should nevertheless still be decided by the court, not by the arbitrator, and so suitable directions should be given, if necessary, for an expedited trial. And as I said earlier, my client would be more than happy to do everything possible to cooperate in an expedited trial if that was thought appropriate. Okay, on the question of whether there can be an appeal against arbitration awards, I do have behind me an American attorney who's come over from New York. There is no general right of appeal under US law. There is, under the JAMS procedure, an optional appeal procedure, but it must be agreed by both parties. And there is no agreement here for an appeal in this instance between the parties. So, my lord, unless I can help further, those are my submissions.
Thank you.
Good afternoon. Mr. Riley-Smith and myself weren't entirely clear on which of us your lordships wanted to go next, but from a glance, I take it perhaps it's me. Start with 3 preliminary observations, if I may. Number 1 is about the wider public importance.
I should perhaps say we're not expecting Mr. Riley-Smith to volunteer submissions. We've reserved a little time to put things to him if we need to, and we will give you an opportunity to respond on that if you feel it's necessary in the light of our questions at the time.
Lord, forgive me for rising. Given my name was mentioned, I thought I might. I have noted down a few of the points that you raised with my learned friend in the course of his submissions, and if insofar as I can assist with any of those, I'd be happy to do so. it may be that it would be helpful if I produced a couple of further authorities, particularly on the issue of the Consumer Rights Act, the test, not least the authority to which you have been referred, but which isn't in the bundle, a case of Cavendish, which helps, I hope, very much with the test. But with your permission, and forgive me for interrupting, I might beaver away overnight and produce those if it would assist, but I'm conscious that I'm here with with permission on a very limited basis, and I don't want to trespass on either your patience or go over the bounds of my authority.
Why don't you put the points on paper overnight, send them to us, and then we'll take it from there.
I'm very grateful.
3 preliminary observations. 1, the wider public importance of the issues arising on this appeal. Grounds 1 and 2 are questions of statutory interpretation, and to that extent will create precedent. But as your Lordship's identified, they do not bear on English consumers insofar as they seek a declaration of non-liability on the substance of a dispute before the courts of this jurisdiction. By contrast, ground 3 is about the exercise of a discretion on the facts. Facts of this case are most unusual for an alleged consumer dispute. The alleged consumer made a purchase for over £500,000. A consumer purchase of that value must be a very rare animal. The overwhelming majority of the population never spends such a sum, and for those that do, it is only when buying property with the assistance of a solicitor. That ties into the dispute about whether the appellant is a consumer at all. Of course, in the vast majority of cases, there will be no doubt about a consumer's status. But here it is disputed. The assumption that the appellant is a consumer was only accepted below in light of the good arguable case threshold, as developed, on jurisdiction for the purposes of the CJJA. That's why paragraph 40 of the judgment, which you were shown, is under the jurisdiction section of the judgment, which deals with the CJJA. It uses that phrase, the available evidence, which comes from the case law relating to good arguable case or better view, etc., as now developed. There was and is no concession that Mr. Soleymani was a consumer when that triable issue arises for determination on the balance of probabilities, either at a Part 7 ordinary trial, if the court has jurisdiction over his claim because ground 1 succeeds, or at a Section 9(4) trial, if that is what is ordered. The position was made entirely clear in a previous skeleton on behalf of my client, which is quoted at footnote 4 on page 18 of our skeleton, page 69 of the court. The italicized section at the bottom of that page is taken from Nifty's skeleton on the transfer application, which Mr. Felt says he also showed the deputy judge on the application from which this is an appeal. The position is also made clear in Mr. Weddin's third statement, paragraph 8, supplementary bundle, page 91. There's a wider point. The false premise of my learned friend's position is that where a party applies for a Section 9 stay and includes in its application a case that triable issues arise, the party nonetheless implicitly concedes those triable issues for the purposes of the Section 9(4) balance of probabilities analysis. Of course, on the facts, Nifty did nothing of the sort, and we say that is further put beyond doubt by paragraph 102 of the judgment. That is page 128 of the core. And now we are in the section of the judgment dealing with Section 9, and in particular Section 9(4). And the judge said the claimant has shown plausible evidence that any contract he concluded was a consumer contract. That's his good arguable case. He was a consumer. The defendant had conceded that the claimant was a consumer for the purposes of his application to challenge jurisdiction or seek a stay. This was a useful concession, as many of the points were questions of law, for example, as to the arbitration exception. However, the defendant made clear that it reserved its position on this question should the substantive merits of the claimant's claim ever need to be determined. In context, and in light of the clear reservation of position, that is shorthand for to be determined on the balance of probabilities, either in the context of Part 7 or in the context of a Section 9(4) trial. The appellant also takes the point, it would seem, that all consumers are the same, and that goes into the debate about the notional consumer. The appellant is right about that for the purposes of the CJJA. But that is certainly not the case for either the Consumer Rights Act or when applying Section 9(4) of the Arbitration Act, and I'll come back to that. So ground 3, we say, is the exercise of a discretion on the facts, which are really at one extreme in this case. Ground 3 could only become an issue of wider precedent if the appellant is correct that there is a bright line rule to the effect that the discretion arising in the event Section 9(4) becomes relevant must not be exercised in favour of deferring to the tribunal if a party is even arguably a consumer. We will show tomorrow why there is no such bright line rule of law. Second preliminary observation, some further detail and update on the developments in the New York arbitration. As you will have seen, the arbitration has been running for nearly a year, having commenced on the 29th of July 2021. On the 7th of December 2021, His Honour Judge Katz ruled on the appellant's motion to stay. We've looked at that briefly in the supplemental bundle, so I won't dwell on that. That's tab 11, page 100 and following. Briefly though, on page 100 itself, we see the 3 headline points taken before the tribunal on that motion. 1, there is no valid agreement to arbitrate. 2, the party's dispute is presently pending before the High Court in England. 3, the arbitration provision on which this forum's jurisdiction is based contains terms that are contrary to English consumer rights law and the JAM's policy on consumer arbitration. Reliance was then placed on Section 15B of the CJJA, which we will say is inapplicable to arbitration agreements. Page 107 had the key reasoning on competence, and that at page 108 was the answer to the present application. The issues of the validity of the arbitration agreement were effectively postponed to the final hearing or final award because of the overlap between the jurisdiction and the merits. Those issues have not been foreclosed against the appellant. To be clear on the status of the JAM's consumer policy, it is currently being applied, although that has not been finally resolved. We see that from a ruling the same day as the dismissal of the motion to stay. Page 119, December 7th, 2021. Having reviewed submissions which the arbitrator had unilaterally requested, the arbitrator concluded that for present purposes the preliminary determination made by the JAM's national office that the JAM's policy on consumer arbitration shall apply should remain undisturbed. Subsequently, on the 21st of January...
Sorry to interrupt, but how does that fit with paragraph 5, which says the consumer must have a right to an in-person hearing in his or her hometown area? Is the arbitrator doing that for the time being?
Well, the answer is that where the policy applies, that is a right, but on a proper construction of those rules, it needs to be requested. And as your lordship said, it does not appear any request has been made. And the obvious inference is that Mr. Soleymani didn't want to ask for a hearing in Liverpool because that would have undermined his position on this appeal. If it was said, and we'll come back to the minimum standards, which will also apply for the cost of the arbitration to be paid by Nifty in any event. That's the arbitrator's fees, say, for example, any flight to Liverpool. But that right is...
So the consumer policy provides that, or the
consumer policy provides that. Right. And there's a provision on costs at item 7. But we'll come on to that when we're looking at the comparative analysis for section 9 and indeed seeing why it cannot be resolved summarily. But the short answer is there is no evidence.
You say it's not being applied because it hasn't been requested.
It's been requested. What we then have at page 120 is the procedural order number 2, which has obviously already been seen by some of your lordships. And the update, implicit in what my learned friend said when he detailed some of the depositions, which I've not seen, is that discovery has been completed, depositions have taken place, and so the countdown is afoot to the hearing on September the 13th and 14th, and in particular, as one sees from item 7, to the pre-hearing submissions being filed on the 29th of August 2022. What we then have at 122 is a further order of the tribunal that postdates the deputy judge's decision. After that decision, presumably with one eye on this appeal, the appellant, Mr. Soleymani, asked for a ruling on whether English law would be applied, and we say the answer that came back was neutral and even, and we don't accept the suggestion that it's effectively a closed question. The final determination as at that date, on page 123, respondent's request for a determination as to controlling law is denied without prejudice to reconsideration following the evidentiary hearing and full briefing by the parties. The arbitrator is open to the parties' input on whether this issue, i.e. controlling law, should be addressed in the pre-hearing briefing, i.e. the submission that's due on the 29th of August.
But are you going to be? Is your client going to be contending that the governing law is the law of the state of New York without regard to its conflicts of law provisions? As I'm just reading from clause 16 of the your terms and conditions.
My assumption is yes, I don't have any instructions to the contrary, and that is the contractual provision on which we say we are entitled to rely, including by reference to English conflicts of law provisions, and I'll come to that in due course.
Okay.
The other development is detailed in tab 12 of the supplemental bundle. On the 21st of January this year, the appellant brought a further motion, this time a motion to dismiss the arbitration, effectively seeking summary judgment on the merits. The submissions on that are at supplemental tab 12, and we will have to revisit those in due course tomorrow, because they highlight the overlap between the section 9.4 issues and the substantive issues on the merits in the arbitration. Your Lordship raised this morning the possibility of an expedited trial between now and the evidentiary hearing on the 13th, 14th September. Our position is that that is not physically possible in light of the steps that have to take place between now and any section 9.4 trial in this country. The third preliminary observation.
So just before you leave the course of the arbitration, the evidentiary hearing is to take place September 13, 14, and is that then, does that then envisage there will be no more evidence and there will simply be written post evidentiary hearing briefs? Is that the way it works?
There is no evidence on that, and I don't have any detail on New York practice, but as a matter of international arbitration practice, that would be the norm. The third preliminary observation. We say there are two flawed themes throughout the appellant's submissions. The first flawed theme is that consumer protection from arbitration agreements needs to be all-encompassing and absolute. And so provisions as to jurisdiction, which impact consumers, must be construed accordingly. We say that is bootstraps as to whether consumer protection is all-encompassing from a jurisdictional perspective based on the relevant legislation and case law. The second flawed theme is that the appellant says if it's right in his repeated assertions for the purposes of the jurisdictional issues, it follows that it should also succeed on the merits before this court. And indeed, after lunch, it was said vice versa. By succeeding on the merits, he automatically succeeds on jurisdiction, i.e., overall, the arbitration agreement should be invalidated. That is a non sequitur, not least because the jurisdictional issues are approached on, broadly, the good arguable case basis, whereas the question of whether the arbitration agreement is binding raises triable issues, including a number that have been debated with my learned friend this afternoon. Ground of Appeal 1. This is a question of interpretation of the sole jurisdictional gateway on which the appellant has relied.
Well, is that a sensible moment to pause and for you to go on tomorrow?
I'm grateful.
Court rise.
10:30.